Hello there, and thank you for joining us for a Trustees podcast brought to you by the Illinois Community College Trustees Association. I am coming to you live from the Quad City campus of Black Hawk College, located in Moline, Illinois. And I'd like to thank Black Hawk College's Board of Trustees and Black Hawk College's marketing department for their time and resources in making this podcast possible today. And before we jump into our topic for today's podcast, I'd like to briefly introduce myself. My name is Allison Wright, and I am a partner and shareholder at the law firm of Pappas Wright PC, located in Rock Island, Illinois. Our firm focuses exclusively on management, labor, and employment matters and clients, and I lead our higher education law division, which means I have the distinct honor and privilege of working with trustees like you on a daily basis. But enough about me. Let's go ahead and dive into our first topic for today.
Now, as you know, your role as a trustee is a very important one, as it places you in a special relationship with the community college district you serve. So today, we are going to take a little closer look at your fiduciary duties as a trustee. And today, we're going to talk about the three main fiduciary duties that govern your relationship with the college you serve. Specifically, we'll talk about the duty of care, the duty of loyalty, and the duty of obedience. And after we discuss those duties, I'm going to walk through three practical trustee takeaways for receiving complaints, handling confidential communications, and managing the balance between being a friend and being a fiduciary of the college. So before we talk about the individual duties, I've included on this slide a brief overview of what a fiduciary relationship definition looks like on paper. It has so many different meanings and comes into play in so many different situations, but in general and overall, a fiduciary relationship is one of trust and confidence between the parties. It includes someone who has special responsibilities to the college in this situation, especially as they relate to administration, investment, monitoring, or distribution of college assets. Now, this can include tangible items like buildings, grounds, or facilities, or intangible items such as the college's reputation or its role in the community or college district. Notably, your relationship as trustees is different from anyone else because it creates duties unlike those that are held by faculty members, students, and even administrators. Now, I do a lot of board governance advising in my practice, and a question I've been asked from time to time includes, where does my fiduciary relationship come from? Well, put simply, it comes from both internal and external sources, and there are many, and they include various sources. Stated most simply, the internal sources include things like your specific board policies or something like your trustee code of conduct. And external sources include those not created by your institution, but by the state of Illinois or even federal law. So there are numerous sources of Illinois law that will impact your duties to the college as a trustee. It is a combination of all of these sources, in addition to your fiduciary relationship definition, that will dictate the way your board governs the affairs of the college. In general, good governance requires many things, but for purposes of this podcast, we can keep it simple and focus on the fact that good governance certainly requires trustees be informed about their fiduciary roles and obligations. And as part of that, as we are walking through things today, it is helpful for trustees to be trained on real-life situations that you are likely to face while serving in your role. And so we will cover some examples of that today. But for good governance, it is also crucial that every board member always be aware of two things. First, your trustees' individual fiduciary responsibilities. And second, the fact that the board acts together as one governing body, not as separate counterparts or individuals. So let's chat about the three main fiduciary duties. First, we'll start with the duty of care, which requires trustees to carry out responsibilities in good faith using the degree of diligence, care, and skill which an ordinarily prudent person would reasonably exercise under similar circumstances in like positions. Ultimately, what this means is that trustees must act in a manner that he or she reasonably believes to be in the best interests of the college that you serve. Now, I'm sure you've heard time and time again that you must act in the best interest of the college. And how do we define that? Well, there's no mathematical formula. But I do want you to know that under the law, the best interests of the college are defined by you, the trustees of the college. Now, that doesn't mean that people may not disagree with you, but remember, you are vested with the authority to determine what those best interests are. and that is left to your sound and reasonable judgment. But in order to reach a defensible position on what is in the best interest of the college, trustees will want to do what you always do, which means you'll want to balance all the various factors at issue with any decision. That includes balancing interests, balancing priorities, analyzing and considering the college's mission and strategic goals. And as part of that balancing act, you will give direct attention to trade-offs. So by way of example, I've identified various stakeholders of a community college and given examples of what their interests or priorities might be relative to a decision made by the board. So for employees, it could be something like maintaining quality of education and protecting college assets. For students, an interest of theirs might be maintaining affordability. As for physical assets, we're talking about buildings and grounds, fiscal assets such as donations, grants, and fund balances, looking to the consumer degree value, which is the cost of degree attainment, and balancing that against future job earnings, and then looking at community interests at your college, including jobs and economic development. Now, there is no one-size-fits-all definition for all actions required by the duty of care, but I've included some examples of ways to fulfill that obligation on this slide. Examples include regularly attending meetings, reading and evaluating meeting materials prepared for the board in advance, asking questions and participating actively in board discussions, being knowledgeable of the college's purposes, operations, and government, and maintaining confidentiality during and after board service. Now, I do want to point out that while the duty of care requires board members to be informed of the issues before you, that does not mean that you have to have any particular professional expertise or knowledge in order to make an informed decision with your vote. As stated here on this slide, the duty of care does not require professional expertise, extensive consideration, or even full knowledge of the matter at hand by every board member. So what is required? Well, what's required is that you be reasonably well informed of the relevant issues before you. And you do have the right to rely on information presented to you. And that information can come from various sources, such as employees, legal counsel, accountants, or subcommittees of your board. In order to fulfill your duty of care, trustees are able to rely on information that is presented to the board. You are not required to conduct an independent analysis or investigation on every decision or every element involved in a decision-making process, but being reasonably well-informed does require knowledge of the relevant issues. Now, this slide isn't telling you anything you don't already know, and in fact, it simply outlines some of the things you consider naturally in every decision that you make. But as trustees, you may have to explain a decision you've made, and as part of your duty of care, you can't say you just went with a recommendation. You want to make sure to discharge your responsibilities under the duty of care, that your decisions are based on reliable information. So you should consider things like the source of the information to the trustee, the source of information to the reporting individual. Did they witness it firsthand? Are they reporting something they heard? Did they receive a complaint from someone else? You'll always want to consider the nature and extent of the information. Is it a brief summary with major themes, or does it include an extensive analysis? Whether a matter is routine or exceptional may always assist in the reliability of information. A routine monthly purchase may require less review than an exceptionally large purchase that was not even part of the budget. And lastly, I've included looking at the time frame in which a decision must be made. This is often a key factor in evaluating the reliability of what you're being told as well. Again, you're always naturally considering and evaluating this, but it is helpful to note that evaluating the reliability of information provided to you, which forms the basis of your decisions, is all part of the duty of care. Now we're going to transition from the duty of care to the second fiduciary duty, which is the duty of loyalty. The duty of loyalty requires trustees to act in good faith in a manner reasonably believed to be in the best interest of the college and its public purposes rather than their own interest or the interest of another person or organization. The duty of loyalty is all about exactly that, being loyal. Trustees must be loyal to the college and not use the position of authority to obtain, directly or indirectly, a benefit for themselves or for another in which the trustee has any interest. And in terms of loyalty, it is important to remember trustees must be loyal to the institution. not to any individual group or organization. You must also ensure that your actions are never driven by any personal relationships you may have with the president, with administration, or other board members. So in determining your loyalty, the two factors at issue include a board member's individual interests and their position as a trustee. But what about those who elected you to your position? Don't you as trustees answer to them? Do you owe it to them to address the issues they, or you both, found important? In many ways, yes, you do answer to them, but it is important to remember that under the duty of loyalty, trustees must prioritize the interests of the college over any other interest. You should be respectful of the views of appointing authorities and groups or individuals, but trustees should never allow that influence to be the determining or driving factor for board action. To check any decision under the duty of loyalty, you just ask one simple question. Is this decision being made in the best interest of the college as a whole? If yes, then you've satisfied your duty there. Now, the third and final duty we're going to talk about today is the duty of obedience. And this is largely about compliance with rules and regulations. The duty of obedience requires trustees to ensure that the college is operating in furtherance of its stated purposes, which are often set forth in institutional documents, and operating in compliance with the law. And to do that, trustees must make reasonable efforts to ensure the college is both legally and ethically compliant with the law and its internal, external rules or regulations. During the introduction, I identified a handful of authorities that govern your board conduct, including board policies and Illinois state law. I would also point out that sources such as your college's mission statement or core values can also govern your conduct as a trustee. And as part of the duty of obedience, trustees will want to look at and review all applicable board documents to ensure decisions are consistent with the principles stated there. Now, this slide includes a few helpful steps to ensure compliance with those governing sources. Periodically reevaluating college's purposes and mission, being prepared to amend or change those as necessary, maintaining an awareness of current or new laws, and evaluating internal controls to achieve compliance and identifying and addressing problems are all helpful steps to ensure that level of compliance that you'd like.
So far, we have discussed 3 fiduciary duties for you as a trustee for your community college in the state of Illinois: the duty of care, the duty of loyalty, and the duty of obedience. And it's great for you to understand those rules and regulations and those governing sources. But understanding the rules only gets us so far. We really need to look at what those rules look like in practice every day as a trustee as you face real life situations. So now we're going to take a look at some of those real life hypotheticals and how those might impact you and how you should act when faced in those situations as a trustee.
And for that, we're going to look at a few trustee tips or takeaways related to the duties of care, loyalty, and obedience for receiving complaints, confidential communications, and then looking at you being a friend versus being a fiduciary with the college. As a trustee and as respected members of your college district, it is no surprise that you will receive a lot of information during your term on the board, and it will come from a lot of different sources. It can come from executive officers or administration, faculty members, staff employees, students, or members of the public or your college community. And what you say as a trustee can have significant legal implications for you individually and for the college as a whole. So how you respond to that information is very important. Now, I'm going to walk you through a brief 3-step complaint receipt process to identify some of the best practices to follow. Step 1, listen. When someone brings a complaint or information to you as a trustee, the best thing you can do is listen. You will want to receive the information, ask clarifying questions, and rephrase to confirm you're understanding the concern correctly. And remember, at the time of intake, you're going to refrain from casting any judgment as to the truth or merit of what is being said, because notice to the college is one major avenue for someone to impose liability. At the time of intake, you will also want to confirm if this is the initial report or if information has otherwise been reported. When the college is put on notice of a concern is absolutely crucial in almost all types of claims. So if you are the first person to learn about it, this is the first time the college has had an opportunity to address it. If it is a situation where someone says this has been reported and nothing has happened, you should additionally be ready to act quickly. But in general, for step 1, you listen and obtain the information. And I've included a very basic example on this slide where someone approaches you and says, I've been having issues with my supervisor and I don't know who to turn to. So some questions to consider at that point: who the supervisor is, what issues they're having, and whether or not this person has shared the information or reported it to anyone before talking to you. Now, moving to step 2, you are going to acknowledge what you've heard, but most importantly, you're going to acknowledge without affirming anything. You will confirm that you take the concerns seriously, state that the college will take any appropriate action as necessary, and tell them your next steps, such as if you will report this to the board or discuss it with someone else. You may also need to direct that person to go directly to someone else. Now, we spend a lot of time at our firm in litigation learning about the conversations that happened at the time a complaint or a concern is reported. Plaintiffs' attorneys focus heavily on what was said and how the information was received. So for you, as members of the governing body for your college, the way you receive information is very important. And in order to balance your duty of care, duty of loyalty, and duty of obedience, you want to make sure you don't do any of the following. Apologize. Do not say, I am so sorry this happened to you. I am so sorry you were harassed. I am so sorry you've been mistreated. Or on behalf of the college, let me apologize. In the absence of an investigation or reasonable review of what has been reported, you do not want to affirm the information provided is true because it stands at that point as allegations alone. And on the flip side of that, you do not want to suggest that the information provided is false. You need to refrain from stating or even suggesting that a particular course of action will be taken, and make sure you do not state or even suggest again one outcome will result without the benefit of reviewing the issue or the concern or the information. So building off of the same very basic example, I've been having issues with my supervisor and I don't know who to turn to. An appropriate response would be something to the effect of, thank you for letting me know. Of course, the college takes these concerns very seriously and will take any steps necessary going forward. Since this involves your direct supervisor, I'm going to share this information with the president so he or she can begin working through that process. I anticipate that he or she or human resources will be in touch with you soon. Now, after the initial intake occurs at the end of step 2, you move on to step 3, which does require you to act. At the third step, a trustee should escalate, which means you need to take action on the information you have. In most cases, this will mean forwarding the information onto the president or to the board, or both, to determine how the board wants to proceed. It is important, again, to make sure that when you do escalate the concern, that you report all the information given to you. When I say plaintiff's lawyers focus on what was said during complaint intake, what I mean is that they obsess over it. At the time of complaint receipt, do not evaluate what is relevant or important. You will want to pass along all information that you have. And again, I have a list of things we want to avoid so we can fulfill the duties of care, loyalty, and obedience. In terms of escalating a complaint, we recommend you do not allow concerns to fall on deaf ears, meaning you cannot ignore the information that is shared. As a trustee, it is not your responsibility or your duty to conduct an independent investigation unless you are otherwise designated by the board. And again, when you escalate the concern, you will want to refrain from making any assumptions as to the truth or falsity of the information shared, because this could taint the entire process moving forward. For example, if someone reports they're being sexually harassed, but you've heard this employee complains about everything. So when you forward on the complaint to the president, you also share, I'm sure it's nothing. I heard Allison complains about everything under the sun. This information in this statement could put the president in a position where they are forced to either disagree with you or agree with the premature conclusion. Either way, you must let the process run its course. So using our basic example again for step 3, if the employee reports, I've been having issues with my supervisor and I don't know who to turn to, one example of action required when you escalate would be reporting the concern to the president and following up with the president thereafter to confirm HR or someone else is handling and moving forward with the complaint. Now, another important part of your fiduciary duties is how you handle confidential information. And you will undoubtedly have a lot of confidential information come your way as a trustee. It could include confidential personnel or employee information, sensitive student information, competitive information of the college, the list goes on and on. My best advice for any confidential information you obtain as a trustee is very simple. Keep it confidential within the board. Now, information can come from various sources. It could come from closed session discussions, subcommittee investigations, confidential communications with officers or administration, or confidential communications with legal counsel. Sometimes a helpful rule of thumb is looking at the exceptions under the Illinois Open Meetings Act or the Illinois Freedom of Information Act and seeing if the board has authority to discuss privately in closed session or keep certain documents from disclosure. And if they do, then you should know that the information especially should be held in confidence from those outside of the board. So on this slide, that is why you see the general rule of thumb that many trustees find helpful, which is looking to FOIA and OMA. If the information is subject to a FOIA or an OMA exemption, make sure that you maintain confidentiality. Now, even if it is not, be cognizant of the manner in which you obtain that information if it is not publicly known. It's not just those exceptions that will drive your duties to maintain confidentiality here. And speaking of confidential communications, let's walk through a closed session example here. As you'll see on this slide, during closed session, the board is updated on a threatened harassment lawsuit involving 2 students. The alleged harasser is actually the son of an administrator. The alleged victim has retained a lawyer who has contacted the president. The president and legal counsel share that the alleged victim simply wants to be transferred out of a class so that she can avoid interactions with the accused. 2 days after the board meeting, a trustee runs into the administrator at the grocery store. The administrator asks the trustee if she has heard about the situation with the students. She states that the harassment allegations are false. How should the trustee respond? Now, first and foremost, the trustee should not make assumptions at this point, but it is okay for the trustee to state that the college takes all allegations seriously, refrain from sharing information about the status of the complaint or the investigation or any other information that was otherwise shared in closed session. And it is okay for the trustee to inform the administrator that as a trustee, they cannot discuss the facts related to this incident since they're not in charge of it. They're not in charge of the investigation. And it would be best to direct the administrator to forward any relevant information they have to whoever is the designated investigator. And lastly, you should advise the rest of your board of the interaction that took place. Now, sometimes these communications can hit a little bit closer to home, or they get a little bit more personal for a trustee. So here we discuss an example that highlights the issue of you as a trustee being both a friend to someone and a fiduciary to the college. The example reads, a trustee is approached by a faculty member who the trustee has known and been friends with for years. They catch up on their usual topics, and then the faculty member shares that he's been a little concerned about one of the college administrator's sons who the faculty member has in class. He feels that his treatment of another student is inappropriate, borderline harassment even. The faculty member has not reported it because the administrator parent is higher ranking at the college, and he fears that if there is not merit to what he has perceived, it could jeopardize his job. He tells the trustee he doesn't want the trustee to do anything with the information. Now, does the trustee have the option to do that, to do nothing with the information? Now, we see this a lot in litigation. Again, the issue of when the college knew or should have known about misconduct or concerns is crucial to providing an adequate legal defense. So we never want to have information that requires us to act and then simply chalk it up to saying that your friend was venting to you or brush it off as just talk amongst friends. So how should the trustee respond here? Again, I give examples of what the trustee can do and should say. Let your friend know the college takes allegations seriously. Help them understand that as a faculty member, they should report those concerns to administration on their own. And while it may be uncomfortable, given your friendship and history, you should let them know that as a trustee, you cannot discuss facts related to this incident because you are not responsible for looking into these types of situations individually. You should tell the administrator to report the information and let him know that you will need to do the same. Then you need to advise the board of the interaction and notify the president of the concern raised. Each of you, as trustees, has a very special relationship with the college as fiduciaries. And from your daily interactions to your board actions by vote, those duties play a role in what you do and what you say.
So today we've discussed the 3 fiduciary duties that apply to you as a trustee of an Illinois community college: the duty of care, the duty of loyalty, and the duty of obedience. And after going through the real-life examples that we just discussed, It is my sincere hope that you understand exactly how those duties apply to you and you have real-life examples to apply in your daily operations as a trustee. If you need any further information or have questions about this podcast, you can certainly reach out to the ICCTA resources that you have available to you, and you may also contact me directly if you have questions about the content from this podcast. Thank you very much for your time.